Today, we're diving into a really fascinating and, let's be honest, often controversial world, the place where psychiatry and the law collide. It's an area where the human mind itself is on trial, and the questions, well, they're about as complex as it gets.
So let's start our story on a street in London, way back in 1843. A man named Daniel Macnaghten pulls out a pistol and, in broad daylight, shoots Edward Drummond. Now, Drummond was the private secretary to the British Prime Minister, Sir Robert Peel. Turns out, Macnaghten was convinced the Prime Minister was the head of some vast conspiracy to persecute him. He actually meant to kill Peel, but shot Drummond by mistake.
At the trial, the evidence was pretty overwhelming. I mean, Macnaghten did it. But then something incredible happened. 9 different physicians took the stand, and they all said the same thing. Macnaghten was suffering from profound delusions. He was, in their professional opinion, insane. So the jury came back with a verdict that just shocked everyone. Not guilty by reason of insanity. The public and even Queen Victoria herself were absolutely furious. How could a killer just walk free?
And that public outrage led to a question that has been echoing through courtrooms for more than 150 years since. How can a person physically commit a crime, be guilty of the act, but not be held legally responsible for it? This is the fundamental puzzle at the very heart of forensic psychiatry.
All right, so here's how we're going to tackle this. We'll start with the legal test that was born from that very crime. Then we'll look at how a person's mental state affects responsibility in just our everyday lives. After that, we'll trace the evolution of mental health laws. And finally, we'll dig into the ethical code that guides psychiatrists through all these tricky situations.
So the public outcry after the Macnaghten verdict was so huge that the House of Lords basically had to do something. They got a panel of judges together to create a clear legal test for insanity. They needed a standard, a rule, to make sure what they saw as a total miscarriage of justice could never happen again.
And the result is what we now call the Macnaghten Rule, which is actually the basis for Section 84 of the Indian Penal Code. It creates a really important 2-part test. For an insanity defense to work, the defense has to prove that because of a mental illness, the accused either, 1, didn't understand the physical nature of what they were doing, or 2, they didn't know that what they were doing was wrong or against the law.
Now, I want to be really clear about something. This is not some get-out-of-jail-free card. The law automatically assumes everyone is sane. So the burden of proof is entirely on the defense. They have to actively prove that the accused met that very specific criteria at the exact moment the crime happened. Just having a mental illness is nowhere near enough.
But, this whole intersection of law and psychiatry goes way beyond dramatic criminal courtrooms. What about civil responsibility? All the everyday legal decisions and agreements that shape our lives? Well, they're also deeply connected to a person's mental state.
Think about it this way. In criminal law, the big question is guilt. Did they do it, and are they responsible? But in civil law, the question is usually about capacity or competence. Does this person have the mental soundness to make binding decisions for themselves? It really touches almost everything. To get married, you have to be of sound mind to give valid consent. To sign a contract that holds up in court, you have to have the capacity to understand what you're agreeing to. Even being a credible witness requires the ability to understand questions and give rational answers. And in really sensitive areas like adoption, the law looks at the mental fitness of parents to make sure a child is going to be okay.
And that brings us to one of the most common and, let's be honest, most fought over areas, making a will. How on earth does the law figure out if someone has the mental capacity, what's called testamentary capacity, to decide who gets their stuff after they're gone? Well, the courts have a pretty clear 4-part test. First, does the person actually understand that they're making a will and what that means? Second, do they have a general idea of the property they're giving away? Third, are they aware of the people, family, loved ones who would normally expect to inherit from them? And finally, and this is crucial, is their judgment free from any specific delusion that's unfairly influencing their decisions? So just as our ideas about individual responsibility have changed, so have the laws that govern mental health care itself. And this required a massive shift in perspective, moving away from just, containing people to actually focusing on treatment and their rights. India's legal framework has been on a really long journey. You look at the earliest laws, like the Indian Lunatic Asylums Act of 1858, and they were pretty much just about locking people away. The 1912 Indian Lunacy Act was a bit more detailed, but it wasn't really until the Mental Health Act of 1987 that we see a truly modern, rights-based approach take hold. And what's so telling is how you can see that whole evolution right here in the language. The change in the law brought a very deliberate change in words. A lunatic became a mentally ill person. A criminal lunatic became a mentally ill prisoner. An asylum became a psychiatric hospital. And this wasn't just about being politically correct. It was a fundamental shift from stigma to a proper medical framework. And this change in language had a massive real-world impact. The 1987 Act introduced some incredibly important protections for human rights. It explicitly forbids treating a patient with cruelty or indignity. It protects their right to communicate with the outside world. It restricts their use in research. And it set up authorities to actually regulate mental health services. It was a game changer. Okay, but the law is only one part of the story, right? Beyond all the legal rules, psychiatrists are also guided by a very strict code of ethics. You can think of it as the spirit of the profession, governing their relationship with patients and with society as a whole.
The Indian Psychiatric Society lays out these core principles pretty clearly. A psychiatrist has a duty not just to their patient, but to society. They have to stay on top of their game through continuous learning. The principle of benevolence means the patient's interest always comes before their own. And there are some absolute hard lines, like never refusing emergency treatment, or of course, never engaging in any kind of sexual advances toward a patient.
And really, it all just boils down to this one powerful idea. Every law, every rule, every ethical guideline, it's all built on this one foundation. The welfare of the patient is the most important thing. It's the North Star that guides them through all the complicated legal and ethical gray areas. Which leaves us with one final and I think really crucial question. From the McNaughton Rule all the way to modern neuroscience, our understanding of the brain is changing constantly. As we learn more and more about the roots of behavior, our very definitions of responsibility, capacity, and illness are going to be challenged. So the question for all of us is this: as the science of the mind evolves, how must our laws and our ethics evolve right along